PJ, let me zero in on 2 wins in 2024. Kapag binacktrack ko po yung records, si BBM po talaga yung nag-file ng motion to dismiss. As the executor of the estate, heir of his father, yung motion to dismiss niya po, yun, including the Coco Levy case, ay yung was decided in his favor by your division. And you were the ponente. Pag chronological po natin yung event, 2024 po yun, by January, na-appoint na po kayong PJ. So, what do you want to say to those who may perhaps unfairly conclude na, kaya ka siguro in-appoint kasi you penned a decision in his favor, granting his own motion to dismiss?
This I will pose as a challenge to everybody who wants to question the decision, particularly of the 2nd Division that I chair. Walang natutulog na kaso sa 2nd Division. Walang natutulog na kaso kung saan ako ay isang miyembro, kahit junior member ako or senior member o ngayon chair na. Kaya hindi fair, hindi makatarungan na hindi ko titingnan ang kaso na nag-move ang isang defendant who is, by the way, the President. Hindi factor ang kanyang pagiging presidente. But what is the factor there? And that concerns me is that there is a motion and that there are pleadings and we are time-bound to resolve them. I am very particular on the timeline of cases.
PJ, the Marcos cases, they're really so complex. Parang wala pa akong naisulat na Marcos case na hindi ako nalilito. And may mga decisions din na may mga concurring and dissenting opinion na nagpapatunay na nakakalito, pati sometimes kayo hindi nyo na alam yung computation, no? From your view, both as Associate Justice and Presiding Justice, ano ba yung naging challenge ng investigators and prosecution kung bakit pagdating sa korte, parang sobrang a web of cases na yun?
Okay, in these cases, these are the cases that are the civil cases that we have. Ang challenge talaga ng Sandigan is that these cases have been pending for a long time. And palagi siyang umakyat. Isang desisyon, isang order na lalabas from the court, iko-question, pupunta ng Supreme Court. Magtatagal, hindi na naman natin maaaktuhan kasi naghihintay tayo sa ruling ng court, kaya nagtatagal ang kaso. That is the challenge for us because every time the matter or an issue gets back, we need to study the case all over again. Now, in the criminal cases, those cases that are prosecuted by the Ombudsman, I would say the challenge really is the evidence presented, the witnesses that are available. When the case comes to court, witnesses are no longer available. The evidence that's left are mere photocopies. Some could not even be retrieved anymore because of the period that lapsed from the time the act was committed and the time when we start trial. So you shorten the time, then probably there will be more witnesses who are willing to come. There will be more witnesses who are available, witnesses who are not yet dead, or physically incapacitated to come or even testify, and that evidence will still be intact.
Justice, would you say, nasabi nyo nga, ang dami rin kasing defendants and respondents sa mga kaso na to.
Yes.
Factor ba nung delay ay ang dami kasi nila? Minsan, of course, defense lawyers would, sabi nga nila, they would file dilatory pleadings, ganun. Meron din bang ganung nangyari sa mga Marcos
Yes.
cases?
Lalo na, sa Marcoses, you're saying,
yeah.
there are so many defendants, and at this stage, the challenge really is to look for the defendants. Because, well, when some defendants are sent notices, they're not in their address anymore. The lawyers that are part of the case representing the defendants, you know they're dead, but that's a personal knowledge, no? So you have to somehow still go to their known address, serve it, although you know that they're already dead. So these are challenges.
Hanggang ngayon po, parang hindi pa rin magkasundo kung meron pa bang natitirang perang mare-recover kasi some decisions do not involve an amount or sasabihin ng PCGG, actually may compromise agreement na kami, kaya give up na tayo.
Yes.
In your estimate, milyon pa po ba yung pinag-uusapan natin?
Alam mo, in the cases that went through me, it's very surprising, you are right, merong mga compromise agreement na hindi ko naintindihan na binbin siya somewhere na hindi sinabit sa court. So, if only we focused on them, we took a look at them, sana nalaman ng court kaagad na meron na palang mga compromise agreements ito. Of course, meron ding mga milyon doon sa mga compromise agreement na somehow executed already. No? So, in the cases that you have mentioned and probably you have seen, it's not just one that is dismissed or compromised there. So, we have a judgment by compromise agreement. And then there are also some cases, one or two, where the Office of the Solicitor General withdrew. So, you know, it's not, you cannot just say,
Kayo yun.
ako yun. Because, maging ako na yon ang may problema, kung sabi na ng OSG na they have already settled, and yet I will say no. Because ang guideline natin, when a case is settled, if there is a compromise agreement, is for the court to issue a judgment by compromise agreement for as long as the compromise between the parties, meaning the defendants, including the family of the President, and government represented by Office of the Solicitor General is not contrary to public policy.